going to talk about who can be a guardian, who can be a custodian. They're very misunderstood concepts. One of the most recent Second Department decisions that came out in February actually says the distinctions between guardianship and custody are elusive, which I think is a telling quote, because both a guardian and a custodian do have the right and responsibility, as it says here, to consent on the child's behalf and make decisions regarding education, medical care, and their physical, emotional well-being. Custody is governed by Article 6 of the Family Court Act, and it's available up to 18. Guardianship is governed by Article 6 of the Family Court Act and also Article 17 of the Surrogate Courts Procedure Act. Many people think of guardians and surrogate court traditionally for those who may lack the mental capacity to make decisions. New York law specifically provides for guardianship for consenting youth up to 21. And actually, Trudy Ann, one of the appellate decisions in your packet, I think is very unique in that case, the appellate division actually grants an order of guardianship just days before the young woman's 21st birthday, showing that this is something that really is available to youth up until 21. And that there are benefits to someone being named your legal guardian. In fact, in New York, with an order of guardianship, many guardians can place the child on their health insurance up to 24. So, there are benefits that extend even beyond 21. And for many young people, just the powerful nature of having someone stand up at court and say, I want to be this person for you, it's incredibly powerful. And that's also, very meaningful and really does go a long way also towards these ideas of permanency and stability. Yeah, so, and, we're going to talk about this a lot, but there's a recent decision, Marisol actually is a case where a parent is named as guardian of her 18 and 19-year-old children, showing that a parent can, in fact, be a guardian, not just a custodian. It was, many people, thought a parent could be a custodian up till 18, but a guardian up to 21 had to be a non-parent. Which is really a distinction that didn't make sense, and it also was not true if you look historically at what was happening with guardianship. Parents have, throughout time, been named as guardians of their children. So the court recognized that and made clear that a parent can be. And in that case, what's interesting is that the court actually talks explicitly about the fact that they are also seeking a special findings order, and that part of the permanency benefit for this child is also linked to that. The benefits of guardianship are both for an adult and child, that, as we said, the adult can help guide the young person. There aren't express financial responsibilities with being a guardian. However, if a child, so you can become a guardian of the person, and you are not, explicitly saying that you will support the child with a certain amount of money, but you are saying that you're going to care for the child. You are saying that if the child doesn't live with you now and they became homeless, that you are the person who is going to take responsibility for figuring out where that child is going to go. So that's another thing that many times a guardian does not, in fact, live with the child, but they are, forced, and they should show in family court that they are a responsible adult who's meeting regularly with this child, actually guiding them and making decisions for them. And for the, there are a lot of benefits that come from just the clarity of that legal relationship. Also, similarly for a parent seeking custody, even when there's no other person contesting custody, just the fact that you have an order from a family court in a specific county helps to establish residence, which is very important for undocumented individuals. It helps to, again, make it easier to make medical decisions in case of an emergency. It helps to obtain a passport. There are many countries that won't let a mother get a passport for her child, even if there is no man's name on the birth certificate. They still want the father to sign a consent. So. And I'm getting a little ahead of myself, but all of these benefits and rights overlap, so I'm mentioning them now. Again, what is a guardian? We have a lot of slides on this because people have a lot of questions, and it's something that we routinely find people come back to us with questions. Can this person be a guardian? Can this person be a guardian? And I think, the key thing to remember is the most appropriate person to be a guardian is a person who is actually making, or who has said that they will make, decisions for the child, to help them, to guide them, to make sure they're obtaining medical care, education, resources, and services. It can be a parent, it can be a relative, it can be an older brother or older sister, but it can also be someone who's not related. We've had many former teachers who petitioned to be a guardian. The Muhammad case, which is also in your packet from the Second Department in 2010, that was Muhammad's guardian was his former teacher, and he was actually living with him, and he had for several years. I've actually had several cases like that where a teacher or a pastor, even someone else in a community center forms a relationship with a young person, much like a mentor, but they go on and become their guardian. So, and very importantly, the undocumented individuals can in fact be guardians. Just very quickly, in terms of custody, it is important to note that while traditionally people think of custody in terms of parents, often a battle between parents or a decision between parents, in which case the best interest standard applies. There are many non-parents who petition for custody. A different standard does apply in the sense that you have to show extraordinary circumstances before a non-parent can be appointed as guardian. As custodian. But those same extraordinary circumstances are what you are seeking to prove through your special findings order and other ways, that they are abuse, abandonment, neglect. So in many of the cases that we're dealing with, those do in fact exist. Very frequently, mothers go into family court. There is no father on the birth certificate. They are seeking to file a custody petition, and they're told, no, you have custody. Why are you here? You can't get custody. You already have custody. And for all the reasons we already said, and more, in fact, it's often very important for a parent, even a parent who already has physical custody, to establish that they also have legal custody over their child. And sometimes a respondent may not be just, say, the biological father, but also the caretaker with who the child has been living. If the child had been living with a grandparent for 6 years prior to reuniting with a parent, in that case, you may also be naming the grandmother as a respondent on the custody case, and showing that the mother, has properly served her. It's sort of this idea that it resolves questions about who has the authority to make decisions, and in many cases, because informal relationships have existed for so many years and people have been making decisions sometimes without these legal documents, it's particularly important to make sure the child knows that they know who's making those decisions for them. So.